the 29th lecture of this lecture series on international arbitration practice. This lecture is a part of chapter 2 on invoking arbitration in international commercial arbitrations and international investment arbitrations. Lectures 19 to 22 dealt with invoking arbitration in international commercial arbitration, while lectures 23 to 28 dealt with invoking arbitration in international investment arbitration. In lecture 27, we dealt with the portion of the 6th part of the 12-part checklist for invoking arbitration. The lecture 28 also dealt with the checklist. If you're here for the first time, do have a look at the previous 3 lectures. Links to the lectures are in the description below. In this lecture, we continue to deal with a portion of the 6th part of the checklist on arbitration under investment treaty. The 40th item in the checklist is the nationality requirement. The claimant is entitled to raise the dispute. Again, this is important and is one of the main jurisdictional requirements in the investment treaty arbitration. This item has been dealt with earlier in the checklist in terms of serial numbers 15 to 21. The requirement of establishing the claimant to initiate the claim, that is the nationality requirement, is repeated albeit briefly in the notice. You may want to have a look at lectures 9 to 13 of the other lecture series on Introduction to International Investment Law for an overview of the topic from a theoretical perspective. Also, lecture 26 of this lecture series deals with the requirements of notice of arbitration in detail as regards the nationality requirement. Links to these videos are in the description to this video. Now, coming back to the nationality requirement, let us see how an actual notice of arbitration deals with this in the head arbitration under the BIT. The notice in Discovery LLC versus Slovakia states, see, claimant is a company of the other party to the BIT. 94. As set out in paragraphs 87 and 88 above, the claimant is a company of the other party, i.e. the USA. The claimant is a company incorporated under the laws of the state of Texas, which qualifies as a political subdivision of the United States of America, which is the other party to the BIT. As we stated earlier in this lecture, the manner in which the claimant satisfies the nationality requirement under the BIT and the ICSID convention is dealt with earlier in the notice. Note that the above item is only regarding the BIT. The next part of the checklist would once again deal with the relevant portion of the notice of arbitration addressing the nationality requirement under the ICSID convention. The next item in the checklist, item 41, concerns the acts through which rights were impaired were attributable to the host state. State attribution is important. This is dealt with in the notice in Discovery LLC vs Slovakia in the following manner. 67. The measures described above, which prevented the claimant from exercising its rights under the licenses, are attributable to the respondent under international law. Each of the opposing protagonists in the incidents described above are either executive branches of the state, for example, the Ministry of Agriculture and the Ministry of Environment, and so their actions are directly attributable to the state, or they are empowered by the internal law of the state to exercise elements of state authority. For example, the police, the public prosecutor, GUDR, Vladislava, Slosar, Sikova, and the national judicial system. Furthermore, the acts in question were all performed by the relevant individuals or entities whilst acting in the exercise of their delegated state authority. Here, the conduct complained of was of an organ of the state, one of the ministries of the host state. Things get complicated when the conduct complained of is of a corporate entity of the state or a public-private partnership, but that's for another day. Item 42 in the checklist is the declaration that the investment of the investor was one protected under the treaty. In Discovery LLC vs Slovakia again, the notice first quotes the relevant portion of the treaty regarding investments. 89. The purpose of the BIT as set out in the preamble is to protect the investments made by nationals and companies of one party in the other party's territory. Amongst the types of investments that are protected, the following are explicitly referenced. A. Tangible and intangible property. B. A company or shares of stock or other interests in a company or interest in the assets thereof. And C. Any right conferred by law or contract and any licenses and permits pursuant to law, including concessions to search for, cultivate, extract or exploit natural resources. After doing so, the notice, secondly, states how the investments that it had made were protected. 90. As discussed at paragraphs 13 to 15 above, Discovery held an economic interest in each of the licenses. Article 1(1)(a) of the BIT expressly recognizes interests, whether owned or controlled directly or indirectly by the relevant investor, in companies and licenses as constituting investments. Discovery directly owns and controls AOG as its 100% shareholder and indirectly owns and controls AOG's assets and in particular its economic interests in the licenses. Accordingly, through the licenses and AOG itself, Discovery has invested in the territory of Slovakia and its investments are protected under the terms of the BIT. AOG mentioned here is a corporate entity that is active in Slovakia and is a subsidiary of Discovery LLC. Note that the aforesaid portion crisply states that the investment protected under the BIT, while the detailed facts are stated in the earlier portion of the notice, that is paras 13 to 55, which this particular para cross-references. These are important jurisdictional requirements and it is better to state precisely how the jurisdictional requirements are followed. There is no room for vague assertions. Item 43 of the checklist relates to the investments made in terms of money by the claimant. The Discovery LLC notice states in this regard. Furthermore, since 2006, AOG and consequently Discovery has invested a total sum of approximately EUR 20.5 million in the licenses, comprising expenditure inter alia on annual license fees payable to the respondent, on geological and geophysical surveys on the licenses, and on related contractors and consultants. Note that this is not a claim for damages, which is covered in another item of the checklist. We'll deal with damages later. Item 44 and 45 relates to the averments regarding the host state being a party to the ICSID Convention and the details of the BIT respectively. The Discovery LLC notice states in this regard. 92. Article 6(3)(b)(1) of the BIT provides that in the event the respondent were to become a party to the ICSID Convention, it contends to the submission of an investment dispute to the center by virtue of being a party to the BIT. The BIT was executed in Washington in the United States of America on 22 October 1991 and entered into force on 19 December 1992. Article 14 provides for the BIT to remain in force for a period of 10 years and to continue in force thereafter, unless terminated in accordance with the provisions of the BIT. The BIT has never been terminated by either party and therefore continues to remain in force and binding upon Slovakia. 93. Further, the Slovak Republic became a party to the ICSID Convention, having signed the convention on 27 September 1993 and ratifying it on 27 May 1994 with an effective date of 26 June 1994. Thus, this part also deals with ratification to the ICSID Convention in addition to spelling out the details of the BAT and its operation. More on this topic in the next post.